Chris Hicks, New Direction Family Law, coming at you with another Family Law in Court. Today we're going to be talking about digital forensics in the realm of family law. I'm sitting here with Derek Ellington from Ellington Digital Forensics. Derek, why don't you tell us a little bit about yourself?
Well, hey, thank you for that. I'm glad to be here with you guys today. And I guess the oversimplification is that I'm the guy that looks at your phone and looks at your computer and tells everybody what you've been up to. I'm a certified digital forensics examiner, an e-discovery specialist. I'm also a certified fraud examiner, which means that I work with CPAs and auditors, investigators to prosecute white-collar crime like embezzlement and employee misconduct. I'm also a licensed PI. But for the sake of our discussion today, I've been working in the field of digital forensics and family law in this area for almost 20 years. So we've seen an awful lot happen in that time period.
Right. So I think what people tend to think of when talk about family law and digital forensics is infidelity.
The cheating spouse.
The cheating spouse is what comes up. How can I prove it? But it's not quite everything you get into when it comes to our area of law. What else?
And it's interesting because I think that infidelity is usually what gets people in the door. That's what probably prompts people to get to the attorneys. But it's interesting that once we get past the issue of infidelity, there's so many other issues that we have to address. There can be financial information that can be even more important than the question of infidelity. What somebody's doing with their money, where they're hiding their money, what type of accounts they have. And then when we move past that, we can get to questions of character. Maybe it's inappropriate use of their computers, pornography issues. It could be things that, again, gambling addictions or things that affect custody. And it's interesting that people outside the realm of family law can think of a family law case as being just one case, but what we find is that when you're dealing with a family law matter, you may have all kinds of different elements. You may have post-separation support, which is a question of finances. You may have the actual divorce, which could be infidelity or character issues. You get to a custody question, which is their parenting skills, and can pull other stuff into it. So we have situations where maybe we collect one pool of data, and then we have to go back and revisit that data time and time again to answer different questions as the case evolves.
Right, so you may start with an issue of infidelity, but then you may suspect a spouse is hiding money, so then you go into the forensic accounting side of things.
Exactly. Again, there's a lot we can do to look for hidden accounts. Let's say, for example, maybe a review of somebody's web history will tell us all of the places that they're logging into online bank accounts. And we may find references to banks that the client has no knowledge of. And of course, there's a big issue with the forfeiture of undisclosed accounts. So it can be very important to a client to find bank accounts that haven't been disclosed during the discovery process, things like that. Again, character issues. There could be issues where, we think there's hidden money, but the problem is there's no money. And we need to figure out where it went. Was the loss of the money due to the same elements as infidelity?
Right. Right.
Or is it gambling? Is it, like the one case where we couldn't figure out where the money went, but we found a receipt for a mini storage warehouse that the wife didn't know anything about. When we tracked it down and opened it up, we found a sports car in the mini storage unit that the wife didn't know about, things like that. So again, this job, we say it's often tedious but never boring. One of the things that's interesting, though, at how this has evolved over the years is we still have the same elements that we did 20 years ago. It's just the sources of data is different. 20 years ago, 10 years ago, it may be that we have a computer, a desktop computer, maybe a flip phone or a BlackBerry. And nowadays, it's a desktop computer, a laptop, a tablet, it's Facebook, Instagram, Gmail. There's so many sources of data, which helps us for several reasons. I know one of the biggest questions is, well, if somebody's trying to cover their tracks, if somebody's taking steps to destroy data or destroy a device, what can you do with that? And the good news is that in 2019, a person's digital footprint, the average person is so broad and so wide, I think it would shock the average person to see the kind of information that we can find on them. So what I tell people also is that, a lot of times we may not find the specific thing we're looking for, but we can find its footprint, we can find its shadow, because everything is so interconnected. And ultimately, they say everything leaves a trace. Well, it does. So the challenge for us is to be able to follow those breadcrumbs, to find that trace. And the great thing about attorneys, and why I love working with attorneys so much, is I always joke about the fact that I can give an attorney 10% of the information, and they'll go into a court and make the other person think they've got 90% of it. And that's what I love about it. I remember one of the first cases I ever testified in. I met the attorney outside the courtroom, and I gave her a 5-minute rundown on what I'd found, and she went into court and argued it for an hour. And I said, "This is great. I love this."
Yeah, we can do that. That's for sure. So we actually had a viewer in an earlier Facebook Live ask us about having access to an actual device.
Mm-hmm.
I think our viewer had said something along the lines of she had discovered her spouse was cheating, but the phone had been destroyed. How important is the access to the actual device?
Well, we always want the actual device, and there's various reasons. But let's start with, say, a normal scenario, and that is a husband and wife situation. They're still living in the same house. One of the spouses has a concern. They consult an attorney, and in the early stages of trying to gather information, there's a lot of information. Pretty much anything you can get early on is going to be easier and more helpful. And sometimes I even say that less information now, early, is better than full information later. Because, a person in a family law situation who's considering divorce, considering separation, these things, they need to make decisions. A lot of times, infidelity itself, the proof of infidelity itself may not necessarily be the driving force with the problems in the relationship, but for a lot of people, that is the deciding factor. That's the line in the sand. And I've heard people say, look, if I'm gonna go through this process, if I'm gonna separate my family and do these kind of things, I want to know. So to answer the question about information, one of the things we would try to do if we can get involved early on is to preserve as much of the available evidence as we can without the other spouse knowing. And things like, are there home computers, are there shared computers that we can access? If the other spouse is using a cell phone, we could do a whole session on the laws of North Carolina and how they apply to this, but the oversimplification is that you can't trespass in your own house. Mm-hmm. So if there's an electronic device in your house, you have a right to examine it or to have someone help you examine it. Basically, if I were to bring my phone and leave it in your house, right, you could look at my phone. Now, why it might not be the politest thing to do, right, and I know there's a lot of people who would argue this point, but we've taken this all the way to the Supreme Court and back. It's not illegal. It's like if somebody brought a duffel bag and left it in your house, you have a right to know what is in your house. Mm-hmm. How this translates to what we see in family law is that if the spouse has access to a device, maybe it has a passcode, it doesn't have a passcode. If we can find a way to preserve the information, then because it's in their house, they have a right to it. So the device is always our best choice. If we don't have the device, then what are we looking for? We're looking for, maybe access to accounts and stuff like that. But see, that's where that law that I just right, quoted comes in. So let's say, for example, there's a computer in the house, and the person who we're investigating is using the computer. Well, if we come in and we take a copy of it, and that's what's really important about what we do, is we want to first preserve the evidence, make no changes to the evidence, because I have to attest that the evidence is valid and that there's been no changes to it, that the attorneys and the courts can have faith in it. Well, if we take a copy of the computer and then we examine the copy, any information that we look at is on the computer and therefore was in the house. Let's contrast that with, say, someone who sits down in front of the computer and a Gmail account is logged into or a Facebook account is logged into. Well, the problem there is if you start clicking around in Gmail or clicking around in Facebook, you're not accessing data that is there inside the house. You are then committing computer trespass against Facebook or against Gmail. And so that's why you always caution people about kind of doing their own investigation for several reasons. One, because there are there are some lines that can be crossed, and trust me, after doing this for 20 years and testifying almost 200 times in court, I know where those lines are, and my job is to protect the attorneys and the clients. But you also run the risk of contaminating the evidence yourself, and this happens a lot. But I even had a recent case where a lady got on the husband's computer and wanted to see what he was searching for infidelity or whatever. Well, she didn't understand that when you start typing in the Google search box, it's not necessarily telling you the searches the person has done before. It's making suggestions based on what you type in. So she ended up typing in, murder wife because it was on the list and freaking out and stuff. Well, the problem is that when I examined the device, it was in the search history. It was in the search history because the wife had put it in the search history, not the husband. So, it was then left to me to separate the two and stuff. But again, I think the idea is when you get to the point, and I always tell people, trust your vibe. You know the other person better than anybody, and if you think something's up, that's the time, when you go to talk to the attorney, be prepared to tell the attorney what the other person's digital footprint is. Some people to this day, they don't, my husband doesn't use Facebook, he doesn't do this. Or other people, well, yes, well, he's got a smartphone, he's got this, he's got that, he spends a lot of time doing, video games or something. Be prepared with that information, because that can help early on you and your attorney develop a strategy to collect that stuff, because again, it gets substantially harder. Now, we did talk about trying to get stuff ahead of time and collect evidence ahead of time. If we can't do that, the cat is out of the bag, so to speak, that's when the attorney steps in and starts, requesting things through discovery, issuing subpoenas for other information. So let's say, for example, there was a device. The device was destroyed, so I missed my window of opportunity to get it early on. Well, what happens is then the attorney can do things like, if somebody's using an Android phone or an iPhone, one of the most powerful bits of information can be to issue a subpoena to either the Google Play Store or the iTunes Store to find out what apps the person was using, especially when we're talking about chasing the money. When I talk to groups of auditors and investigators, and we're talking about this new digital type of investigation, we talk about how traditional investigations was, give me the bank records, give me the phone records, and that's where you start. Well, nowadays, if you get bank records, what you may see is Amazon, PayPal, Google Wallet, Venmo, and it doesn't really tell you the story. And what the attorney will do, and that's what the attorney's job is to issue those subpoenas to get information from PayPal, to get information from Amazon. We had a situation where we knew that a gentleman was in the company of paid companionship, we'll say, but we didn't know how the money was, where the money was going. We couldn't see the money trail until we took a really close look at his Amazon account. And turns out that the ladies he was associating with had Amazon wish lists. So all he had to do was go on Amazon and pick certain items. They could be there same day delivery if need be. And that's how he was providing the compensation. Well, if you just looked at the records, you would just see, oh, well, he's a big time Amazon person, which a lot of us, guilty as charged. But so going back to looking at the different sources of information, again, the phone records may not tell you the whole story, because now, there's video chat, there's text messaging. Most text messaging, especially if you're using iPhones, you're doing iChat and stuff like that, it's not going to show up on the cell records. So again, we may have to do things like, when I mentioned subpoenaing the list of apps, so many people use different apps for financial stuff now. There's Acorn and Mint and all these other things that allow you to do your budgeting and financial stuff. And so if you issue a subpoena, you get the apps people are using, that gives you a chance to see, okay, well, here's texting apps, here's dating site apps, here's financial apps, and that kind of gives us some traction there to try to kind of piece back together what the person's activity is.
Just looking for a foothold, trying to figure out what's going on.
You got to start somewhere, and that's a really good place to start, because so much of people's lives are tied up in their electronic footprint and in their apps. One footnote is, something as simple as Lyft and Uber. And of course, people have probably seen the meme that says, years ago we were told not to talk to strangers and get in strange cars, and now strange people come and pick us up and we get into strange cars. But think about Lyft and Uber for a second, and what that really means. And what it means is there is an app out there that knows where you were when you were picked up, where you were taken, when you went, how much you paid, and all this kind of stuff. And they have a map of the places that you've gone. And that information is out there. It's information that can be subpoenaed. And even non-traditional stuff. Another funny story I like to tell is of the guy who was also engaged in infidelity. He was smart enough to pay cash for the hotel room, okay? But he was such a cheapskate, he wanted the rewards points. So he would use his rewards points numbers when he was paying cash for the hotel room. A subpoena to the rewards program showed every time he checked in at 3 o'clock and checked out at 5 o'clock. Things like that. So we want the devices if we can get the devices,
right.
But because a person's digital footprint is so widespread, we can work with the attorney, work with the client to be creative and try to find these other sources of digital information.
Okay. And you've mentioned subpoenas a couple times, and I know from personal experience trying to subpoena Google or Amazon, for instance, is difficult. So if your company is brought on as a consultant or an expert witness, are those services that you can help us draft?
That's
for
what
clients?
we try to do, and again, we have the language, we know where the subpoenas go. But here's the real rule of thumb, and that is in a civil case, and there's a huge difference between civil cases and criminal cases. For example, I have a lot of attorneys who will try to subpoena text messages. And in a civil case, you will never get them. It's a big liability for the phone company. If they turn the text messages over, they're not just turning over your text messages, they're also turning over all the text messages for everybody that you've talked to, and then they have to issue, they have to give them all the opportunity to quash the subpoena. So it's a big mess. If law enforcement requests it, they can get it. So in a civil case, there are certain categories of information that you will not get. And the easy way to understand it is just content. For example, if we issue a subpoena to Google and we're asking for email, in a civil case, we will not get it, okay? But if we're asking for IP access logs, for Google location data, for web histories and search histories, that's information we can get. The content, the communications is kind of where the line is drawn. And so what happens is a lot of times attorneys will issue a subpoena asking for a lot of that information and then not get any of it because of that one content thing. Now, Facebook is the same way, but a subpoena to Facebook can get a lot of good information. Facebook is a little bit better about that, the messaging and stuff like that. Email is kind of where the line is sort of drawn with, they'll start, quoting things like the Stored Communications Act. The companies can give you that information. They just they don't want the liability, and in fact, a lot of times the companies will comply with the subpoena but object. So they'll say, "We object to the subpoena, but here's what you asked for." So here's the thing: it's a something you have to navigate. It's a bit of a minefield that you navigate, but if you're very specific with what you're looking for, so you kind of do your homework ahead of time, the date ranges you want, the specific categories of information, you can get a lot of information via subpoenas.
Talking about social media, so Facebook, Snapchat, Instagram, Twitter, all the 400 social media platforms we have out there, is that stuff ever gone?
Unfortunately, it is, and we've I guess built a business off of the reputation of it's those digital forensics guys, they can always find it, it's always there, and trust me, I want people to think that. But unfortunately, a lot of data is volatile. A lot of it can be made to be gone forever easily. That's why one of the reasons why getting our hands on the devices early in the process is so important. But let's say, for example, now we're past that and we do want information from Facebook and stuff like that. Unfortunately, with things like Google and with things like Facebook and Instagram, once you delete it, it's gone. And the reason is because they store so much information. We talked about Facebook is the world's largest repository of photographs, things like that. They store so much information for free that they're not going to store things once you've told them to delete it.
Right.
Now, the caveat is, if you have a situation like a Gmail account, like a Facebook account, and let's say it is accidentally disabled, it is that, and it happens a lot, one spouse will get into the other spouse's Facebook account, shut it down, whatever. Gmail account, they'll go and delete the account. If you contact Facebook and Gmail quickly, and 30 days is usually the limit, but quickly would be within a matter of days. There is a window where they can restore that. So a good rule of thumb is if your account gets wiped out, if you work quickly, you can regain access to the account. However, what's very important is that's where your recovery information comes in. When it asks you to set a recovery phone number or recovery email address, those are critical to prove that you actually own the account. So it's a security thing, but it's also a way to establish later that you own it. Because if there's just a Gmail address with a password and you get locked out and you don't have the password anymore, you have no way to prove it's yours, even if it's your name on the Gmail account. John Smith at Gmail, well, there's probably a million John Smiths. So the recovery information is also very helpful for that.
So another issue we come up with in custody cases in particular are, what are my kids doing when they're with their dad? What are they doing when they're with their mom?
Well, and I'm glad you went there. That's something that, and anyone who follows us on social media understands that that's something that we're very passionate about. We spend a lot of time actually working with parents and attorneys, judges, guardian ad litems and stuff like that, helping them to look at kids' footprints and looking at what kids are doing on their phone. And unfortunately, we live in a world where we have this, what we call, persistent immersive technology. Our phones are on us all the time. We're constantly surrounded by it and immersed in it. And it does have an impact on it. It impacts how we interact with the world, how we interact with each other. And again, that's a whole thing I could talk for hours on and do regularly. Mm-hmm. But for the sake of what we're talking about here, getting involved in the children's stuff in a family law case is very important for several reasons. Not only is it an issue sometimes of appropriate supervision, are the parents doing what they need to do to monitor the children? And a lot of parents will say to me, well, my kids know it so much better than I do. How do I, if I have a baby Bill Gates in my house, how do I monitor them when they know it better than I do? And the first step is just to talk to them. Talk to them about it. If it's important to your kid, they'll talk to you about it. And as we always say, if they won't talk to you about the silly stuff, they're not going to talk to you about the important stuff. Yeah. But so the first question is, stuff about supervision. Again, one of the other things that comes up a lot, there's also issues of whether there was exploitation or inappropriate stuff going on. That's always a question. Unfortunately, one of the unfortunate side effects of the contentiousness of many family law cases is parents putting the children in the middle. And one of the reasons why we would want to look at the children's communications is because of parents putting the kids in the middle, arguing back and forth, texting with the kids, one parent dumping on the children the drama from the divorce and stuff like that. And trust me, judges don't like it when they see it, so don't do it. But what's also important is, a lot of the issues that surround children in custody cases and stuff like that, I always tell attorneys and parents that the two biggest problems with children and custody and technology is guilt and competition. Mm-hmm. And if you can get the parents to set aside those two things, they can work together. Either one parent is guilty of the situation, so the kid always has the newest, best iPhone. Right. The kid is allowed to watch or play, R-rated video games when they're only 9 because, of competition. And that's a big problem. So that's something that, the parents, the attorneys, everybody has to address. Don't put the kids in the middle. But there's also other things that happen. You had mentioned parents monitoring and GPS tracking. We've had many situations where, one parent will give cell phones or provide cell phones to the children and then use those to track the spouse when the kids are with the spouse. And, those are things that need to be we need to know that that happens, and the
Right.
attorneys need to understand that it happens. So when they draft these agreements, they can take that into account. Make sure that that's not happening. Oh, and one other thing too. One of the biggest hurdles or blow-ups that I see when you have split custody kids, and that is that someone will write an order, and in the order they'll say that the kids are allowed to have private communications with the other parent. So when one kid's with you, they're allowed to talk to the other spouse privately while they're with them. And the problem is, I always ask the judges and I always ask the attorneys to sort of clarify that and say that the child is allowed to have private communications with the other parent, but that's a phone call, okay?
Right.
The text messaging communications between the parent and the child should not be considered private. And the reason is because if I'm supposed to be monitoring my child's overall activity, but yet you say, well, you can monitor the child's overall activity, but you're not allowed to look at text messages between these people, that limits my ability to monitor. And a lot of times, out of fear of crossing that line, parents won't monitor. So I urge parents and attorneys and judges to say communications being verbal on the phone, they're allowed to have private phone conversations, but any emailing and text messaging and stuff, that don't put in a text message something if you're worried that the spouse is going to see it, because that puts us in a difficult position of trying to monitor the children.
Right. Well, and Derek's daughter's actually sitting here with us in the room. So,
she is.
I mean, daughter's dating.
Frantically deleting things off of her phone,
Right.
even though she knows that that's a fool's errand.
Right.
It's okay.
Yeah, I mean, daughter's dating a hoodlum, and you're not allowed to look at text messages, so she just labels him as mom in her phone.
Well, and it's funny you say that too, because one of the things that I talk about a lot when I talk about the downside of the immersive technology is that one of the things that it's done is it's people who've grown up with cell phones and always have their cell phones attached, and they're what we call digital natives. So those older of us who we didn't have cell phones growing up. I didn't get a cell phone until I was well out of college. We're what we're called digital immigrants. Okay. Well, digital natives are the ones who they always have that cell phone on them. They always have it with them. And unfortunately, when parents, when a kid does what kids are going to do with cell phones, and cell phones are part of modern courtship, and things will happen, and kids will use their phone in ways that their parents don't approve of. And the problem is that a lot of times the initial reaction for the parent is to take the phone away from the kid, separate the phone from the kid. And there's a couple problems with that. Well, the first is kind of us older digital immigrants, as we say, a lot of times we don't really appreciate the relationship between the device and the child, in that it's not just, a toy to be taken away. It actually represents a huge part of their personality and how they interact with the world. And what you've done is you've severed their connection to the world. So what happens is a kid will get in trouble with the phone, the parent will take the phone away, the kid will kind of act in the way that the parent thinks is disproportional, and it's because you've sort of severed that connection to the world. And I was talking about that in a talk one time, and one of the mom and attorneys said, well, I don't understand. How is that any different than just putting them on restriction for the weekend, make them stay in the room? And I said, exactly. You don't see the difference. It's a huge difference. Where for a lot of us who are older, a cell phone has kind of become a prosthetic. It's become an appendage.
Right.
People who have grown up with, and our kids who started out as the iPad generation. I mean, we were the Sesame Street generation. We had parkers in front of Sesame Street, parkers in front of Barney. Well, this is the iPad generation. They've always had that electronic device, and it's not just a prosthetic. It becomes a part of their personality. It becomes a part of who they are. So the key is, when you have a problem with children using their technology inappropriately, don't just completely sever them from that, because realize that's their connection. You've taken their friends away and everything else, because that's the majority of how they communicate. The key is, to address the problems the same way you would other things. And I guess a good example would be, let's say you have a situation where your child is acting inappropriately sexually with their phone, okay? And they're doing things that you don't approve of. Well, unfortunately, a lot of times the parents will because they're so upset about what's happening, they'll shame the behavior and put too much emphasis on the behavior in the device and not approach it the same way they would a normal safe sex talk.
Right.
So let's just say if you take the technology out of it and your child, you find that your child is being active, okay? Well, we would hope that you would sit them down, you would have the safe sex talk, you would have the appropriate talk, you would talk to them that way about it, as opposed to completely shaming the behavior. And you're punishing them for something the biology is telling them to do.
Right.
So you approach it from that standpoint. So how you apply that to technology is, instead of shaming the behavior just because they're using technology to do it, approach it from the same way, but talk about it from an appropriateness. Like, for example, understand that when you send an image, it's out there forever. You have no control. Things like that, and approach it from a constructive way. Acknowledge that the urges are going to be there. There's nothing we can do about that, and parents have spent thousands of years trying to find a way to reel in those urges.
Right.
And so use it as an example to teach, as the same way you would teach safe sex, try to teach safe technology.
Right.
And I think that's one of the important things is, talking to your kids about it is very important.
Right, and I practiced criminal defense and juvenile law for a number of years before I started here, and I think it's important for parents to know too, and share with their kids that if you're taking sexually explicit photos, you're disseminating child pornography. You're facing either very serious juvenile or criminal charges depending on your age, and some potential liability as parents as well. So I think
you brought up another point too, that I'm glad you reminded me to mention something as well when we talk about kind of liability and stuff like that. In this day and age, unfortunately, things like cyberbullying, stuff like that is such a big deal. And it's very important that you're keeping an eye on your child's digital footprint, because obviously you don't want your child to be a victim of bullying. But by the same token, you have an obligation to review your child's digital footprint to know they're not a bully. So you have just as much responsibility to keep your child from
Right.
being a bully than being bullied.
And you also have a responsibility as a parent not to participate.
Well, and that's important that you say that too. And I urge caution to parents. Let's say there's a situation where your child, there's another child who's harassing your child, and maybe you go on social media and you say, hey, you better leave my kid alone or else. Well, the problem is there are laws that say if you're over the age of 18 and you're communicating in a threatening or harassing way with somebody under the age of 18, or even an insulting way, that's cyberbullying. So sometimes parents who try to step into a situation like that, and they're using electronic communication to do that, run the risk of themselves getting in trouble.
Right.
Because the person's under the age of 18.
Right. Do we have any questions?
No, I think there's
No,
been a little bit of a lag. We are up and live, but
Great.
yeah, so we can
Well, how are we doing on time?
We're about 35 minutes so far.
Oh, okay.
Yeah.
You got any last bits you want to share with us?
I think that I would say that for the parents, I know we're talking about family law and stuff like that, but people are also parents. And so for the parents out there, if you're interested in the stuff that we've talked about today, and we're ellington.net, and you can find us on Facebook as well. There's some information that I always post about this. There's some really good books out there, especially on Amazon. There's The Teenage Brain, Mind Change. If you do a little bit of searching, I started about 5 or 6 years ago giving talks on the impact of technology on kids. And there was not as much science then as there is now. And thankfully, there's a lot of really good books. There's a lot of good science. I have the benefit of actually being able to travel around the country and talk about this issue. As you can tell, I'm passionate about it. Talk about this issue with lots of different groups of investigators, parents, attorneys, and stuff like that. But for the parents who are interested, do your Google searches. There's a lot of really good information about there. You're not alone. You're not the only parent out there that doesn't understand their kids' technology or technology in general. And there's a lot of good resources out there. Just spend some more time online.
All right, great. Well, I appreciate you coming out.
Love being here, love your beautiful office. I also love an office that has office dogs too. That's
Yeah.
always great. We have
We
one
do.
as
We have
well,
quite
so
a
that's a
few.
good sign for me, so I love it.
And Derek, if it's okay, woman behind the curtain,
Yes.
since we have had some technical difficulties, you guys have been live and the video will still stay posted, but I don't think there was notifications that went out like there normally is. So if we have any follow-up questions after the fact, what is the best way for us to get in contact with you
By
with
all
questions?
means, you can reach us you can email us at ellington.net. You can reach us on Facebook and message us. We love to answer questions. When people contact me about talking, I say the trick isn't getting me to talk, the trick is getting me to shut up. I'll just go on forever. So no, reach out to us. We always love to answer questions and help people. So
Okay.
anything we can do.
All right.
And if there's any questions with the video, we will do our best to get it onto you as well. If they
Hey, and we'll just come back and do it all over again. Why
I
not?
like
Why
it.
not?
I like it.
All right.
Thank you so much.
Well, yeah, thank you guys for coming out. We will see you next month.